Hello, my name is Professor Dubravka Klasicek from the Faculty of Law in Osijek, Croatia, and the topic of my presentation will be inheritance law in Croatia. In Croatia, inheritance law is regulated by Inheritance Act from 2003. It is based on certain principles that govern how inheritance happens after someone dies in Croatia. So the basic principles of inheritance are as follows. The principle of equality of all natural persons, which includes equality of men and women, of children born in and outside of marriage, and equality of spouses, extramarital partners, registered same-sex life partners, and informal same-sex life partners. The second principle is numerus clausus, or closed number, of legal grounds of inheritance. There are only two legal grounds of inheritance in Croatia: a will, which results in testamentary inheritance, and certain facts that Inheritance Act recognizes as prerequisites for acquiring the right to inherit, which results in intestate inheritance. The third one is the principle of the freedom of testation, which states that everyone who is over 16 and has the ability to reason is free to make a will and dispose of their assets in the event of death as he or she wishes. There are some limitations to freedom of testation, the greatest being the right of forced heirs to inherit their forced share. Those heirs are testator's closest family members, and they will be discussed further in this presentation. The fourth principle is the principle of cumulation of the legal grounds of inheritance, also known as partial intestacy. This means that the same person can be inherited by both testate and intestate heirs. In Croatian inheritance law, the principle of cumulation comes into play, for example, when the testator did not distribute all of the property in a will. The part included in a will is inherited by testate heirs and the rest by intestate. Or, for example, if certain testate heirs renounced the inheritance, then their part will be inherited by intestate heirs and the rest by testate heirs that did not renounce their part. The fifth principle is fiscus post omnes, which in Latin means the state after everyone. This means that if there are no heirs, the state inherits all of the inheritance, because in Croatia someone's inheritance cannot belong to no one. It has to be inherited by someone. So if a person died and didn't leave any heirs, or all of them renounced the inheritance, then the state has to inherit. Croatian Inheritance Act has accepted the solution according to which the state is the universal successor, like all other heirs, with one difference: the state cannot renounce the inheritance. If it could do so, then no one would inherit such an inheritance, and that is not in accordance to Inheritance Act. The last principle is the principle of ipso iure inheritance. Inheritance right is acquired at the moment of testator's death. In Croatia, the heir does not need to accept the inheritance. He becomes an heir due to the very fact that all of the prerequisites for inheritance are met. Sometimes someone will be an heir without even knowing it, at least in the beginning. In addition to acquiring the inheritance right at the moment of testator's death, the heir acquires another right, the right to renounce the inheritance. There are four prerequisites of inheritance which have to happen in order for inheritance process to commence. First of all, decedent's death, which is the basic prerequisite, the main prerequisite, so to say. The second one is the existence of heirs which have to be worthy to inherit and alive at the moment of decedent's death. There is an exception to this rule. If a husband died and his wife was pregnant with their child, that child is feigned to have been born already in order to secure its part of the inheritance. The third prerequisite is the existence of inheritance, and the fourth one is that there has to exist a ground for inheritance, which is either a will or certain legal prerequisites prescribed by Inheritance Act. There are certain heirs that are unworthy to inherit certain persons. So, an heir is going to be unworthy if he or she deliberately killed a decedent or attempted to do so. If he or she violated decedent's freedom of testation, and if he or she committed a serious breach of the legal obligation to support the decedent or did not want to provide him or her with the help he or she could have provided without endangering his or her own life, or left the decedent without help in dangerous situations. As I mentioned earlier, every heir except for the state can renounce the inheritance. They can do this from the moment of opening of the inheritance, which is decedent's death, until the first instance decision about inheritance is made. If an heir dies before the end of the inheritance proceedings, or after it, but before the first instance decision is made, the right of renunciation passes to his or her heirs. Renunciation is a formal act that can be made before the court or notary public. If an heir does not explicitly state that the renunciation applies only to him or her, it will be applied both to him or her and his or her descendants. The renunciation cannot be conditional or partial, and it is irrevocable. The heir who renounced the inheritance is treated as if he or she has never been an heir. As a rule, no one can renounce the inheritance before the opening of the inheritance, but there is an exception: an anticipated renunciation. A descendant can make an arrangement with an ancestor to renounce the inheritance that would belong to him or her in advance, while that ancestor is still alive. The same possibility exists for a spouse. If an heir has begun to dispose of the estate, he or she will not be able to renounce the inheritance because it is considered that he or she has accepted already the inheritance. An heir who renounced the inheritance is not liable for the debts of the testator or decedent. Heirs that did not renounce the inheritance are liable for decedent's debts. Heir's liability for decedent's debts is not unlimited. The heir is liable for those debts with his or her own property and inherited property, but only up to the value of the inherited property. So the liability is quantitatively limited. If there are more than one heirs, they are all liable for decedent's debts. If an heir is over-indebted, decedent's creditors can request for a so-called separatio bonorum, which is a separation of inheritance from heir's own property. In this case, an heir will be liable for decedent's debts only with the inherited property. There are certain assets that are not included in the estate. For example, half of the marital property that belongs to a surviving spouse is not included in the estate of the deceased spouse. Also, an allocation in favor of descendants who worked with the decedent can be requested. If a descendant contributed to the increase of the decedent's property by working with him or her, the descendant has the right to request the allocation of the part that corresponds to the value by which his or her contribution increased the property. Also, allocation of household items can be requested. The surviving spouse and descendants who lived with the decedent in the same household at the time of death are entitled to household items that serve to meet everyday needs. Those items are, for example, furniture, household appliances, bedding, and so on, only if they do not have significant value. So now we come to intestate inheritance, which is inheritance based on certain legal prerequisites from Inheritance Act, when testamentary inheritance cannot take place for some reason. Intestate inheritance is based on blood relations, so the heirs are biological children, siblings, parents, grandparents of decedent. It is based on marriage, which can in Croatia happen only between persons of the opposite sex. It is based on extramarital partnership, also persons of the opposite sex. It is based on formal life partnership, which happens between persons of the same sex, and it is based also on informal life partnership between persons of the same sex. When a spouse is mentioned further in this presentation, all of these people are included. And also intestate inheritance is based on adoption. There are certain principles of intestate inheritance. So the first one is the principle of grouping relatives by parentelas, which is the basic system for grouping relatives in lines of succession and is exclusively based on blood kinship. The second one is the principle of exclusivity, which states that it actually establishes the order in which potential heirs are classified as heirs. Those that belong to a closer line of succession exclude from the inheritance persons of a further line of succession. So, for example, if there is an heir from the first line, heirs from the second line cannot inherit. However, there is an exception to this rule. The third one is the principle of representation. If one of the potential heirs does not inherit, part of the inheritance that was intended for him or her will be inherited by his or her descendants. For example, if a mother cannot inherit, her daughter will inherit her part. The fourth one is the principle of accretion. It comes into play only if the principle of representation cannot be applied. So, for example, if one heir cannot inherit because he or she died, the share that would belong to that heir is inherited by another heir who is of the same degree of kinship and of the same quality as the deceased heir. So, for example, a brother's share would go to his sister if he died earlier and didn't leave any children. And the fifth principle is the principle of transmission, which states that what the heir inherited from the decedent after his or her death is inherited by his or her heirs. It becomes part of the property of that heir, and later, after he or she dies, becomes a part of his or her estate. In Croatian inheritance law, intestate heirs inherit in lines of succession. I will go into detail of how heirs inherit in the first two lines of succession because that usually happens. So, the first line is composed of descendants, adopted children and their descendants, spouses, or all persons that are equated to a spouse. All heirs in the first line of succession inherit in equal parts, so they each receive equal parts of the inheritance. If descendants renounce the inheritance, then the spouse is the sole heir in the first line of succession and inherits all of the estate. The second line can be composed of a spouse, parents, and their descendants, which are siblings of the decedent and their descendants. However, there are two variations to this line of succession depending on whether there was a spouse or not. The first variation happens in case the decedent only had a spouse and no descendants. The spouse then doesn't inherit in the first line alone. He or she moves to the second line of succession and inherits one half of the inheritance. The other half goes to the parents of decedent. If one of the parents is dead, the remaining parent inherits his or her share, and the rest is inherited by a spouse. So they still divide inheritance in half. If both parents died, the spouse inherits everything. So in Croatia, the spouse never shares the inheritance with the siblings of decedent. The second variation happens in case the decedent has no spouse nor descendants. Then the parents inherit the entire inheritance in equal parts. If the decedent had no siblings and one of the parents died, the part that would have belonged to this deceased parent is inherited by the remaining parent. If the decedent had siblings and one parent died, the part that would have belonged to the deceased parent is inherited by decedent's siblings. In third line of succession, there are grandparents, and in fourth line, great-grandparents. Theoretically, there are more than 4 lines of inheritance, but obviously that does not happen often, if ever. So now we come to testate inheritance. Testate inheritance will happen whenever a testator left a valid will. Will can be composed by any person who has testamentary ability. There are several types of wills. For example, there are private and public wills, and regular or ordinary and extraordinary wills. Forms of wills are as follows. A will which was handwritten in testator's own handwriting without any further formalities. A will written in front of witnesses. Oral will composed in front of witnesses, which can be made only under certain extraordinary circumstances. A will drawn up before the judge, a court advisor, a notary public, or a consular or diplomatic consular representative of the Republic of Croatia, and an international will. A testator can make a will, but he or she can also revoke it. The revocation of the will can be made by destroying it, making a formal statement of revocation, making a new will, or by certain conclusive actions, for example, by donating or selling parts of the inheritance that were included in a will. The will is null and void if it was made by a person without testamentary ability. If certain parts of a will are impossible to execute or are unlawful, then only those parts of the will are going to be null and void. The rest of the will is going to be valid. The will is refutable if there was a discrepancy between testator's wishes and how it was manifested, if the will was not made in a prescribed form, or if forced heirs' share was violated. And this brings us to forced heirs. Forced heirs are the persons that limit testator's freedom of testation. They are the persons to whom the testator is obliged to leave a certain part of the inheritance, and if he or she doesn't do that, they are entitled to it, even against his or her wishes. From this it follows that the estate is actually divided into two parts. The part that the testator can truly dispose freely of, and the part that the testator cannot freely dispose of, the so-called forced share. The forced share is the part that belongs to forced heirs, and it actually represents a part of the estate that those heirs would have received if there had been no will. If the testator leaves nothing to one of his forced heirs, then he or she can request it and become a testator's heir against his or her wishes, as I stated earlier. The forced share is only given upon request, and that request has to be made in a certain time period. Forced heirs are, as you can see on the slide, decedent's spouse, descendants, adopted children and their descendants. Their forced share equals to 1/2 of what they would inherit if they inherited like intestate heirs. Then forced heirs are also decedent's parents and other ancestors, but only if they are permanently unable to work and do not have the necessary means of living. Their forced share equals to 1/3 of what they would inherit if there was no will. If a forced share is violated, testamentary dispositions are reduced and testator's gifts are returned. Testamentary dispositions are reduced first, and if the forced share is not satisfied, gifts are returned. All testamentary dispositions are reduced in the same proportion, regardless of their nature and scope. It has to be noted that the reduction has to be requested within 3 years from the proclamation of the will. Gifts are returned in the reverse order of the one in which they were made, and the return has to be requested within 3 years from testator's death. Forced heirs can be excluded from the inheritance if they have committed a serious offense against the testator by violating a legal or moral obligation arising from their family relationship, if they have intentionally committed a serious criminal offense against the testator or his or her spouse, child, or a parent, if they have committed a criminal offense against the Republic of Croatia or values protected by international law, and if they have indulged in idleness and dishonestly. Also, if a forced heir is over-indebted or is a squanderer, the testator may in his will expressly deprive that forced heir of his or her forced share, in whole or in part, in favor of his or her descendants or a minor child, or a minor grandchild of a predeceased child, or in favor of his or her adult children or adult grandchildren of a predeceased child who is incapable of work and doesn't have the necessary means of sustenance. At the end of the presentation, I would like to share some key points about probate proceedings. The probate proceedings are concluded as a rule before a notary public that is appointed by the court after the death of the deceased. Probate proceedings are initiated after the court receives the decedent's death certificate, an extract from the death registry, or a corresponding document. The court shall entrust the conduct of the probate proceedings to the notary public and deliver the death certificate to him or her. When a notary public conducts acts in probate proceedings as a court commissioner, he or she is authorized to undertake all acts in the proceedings and make all decisions except for those decisions for which Inheritance Act provides otherwise. Interested parties have the right to appeal or object to the decisions issued. Before the probate proceedings, a death certificate needs to be obtained, an inventory of the deceased property made. If necessary, measures to safeguard an estate must be made, and also, if there was a will, it has to be submitted and proclaimed. The main part of probate proceedings is probate hearing. The persons that will be invited to the hearing are the ones that have an interest to be present, as well as persons who could legally claim an inheritance if there is a will, and the executor of the will if he or she was appointed. At the probate hearing, the notary public will discuss all matters that are relevant for making the final decision in the probate proceedings. After the end of the probate hearing, the notary public issues a decision which determines the composition of the estate, determines who are decedent's heirs, what part of the inheritance belongs to them, whether their inheritance rights are restricted or burdened in some way, and so on. What happens in case of subsequently discovered assets? Those assets are assets that are not covered by the final decision on succession. If, after the decision has become final, assets not covered by that decision are found, the notary public will not, as a rule, reconduct the probate hearing, but he or she will divide the property found by a new decision based on a prior decision on the succession. The notary public will conduct a new probate hearing only if an heir or heirs previously renounced the inheritance or surrendered the inheritance to another heir. If no probate hearing has taken place before, for example, in case estate did not consist of immovables, the notary public will carry it out on its own motion only if the assets subsequently recovered are immovables and rights that are equivalent to immovable assets. So I would like to thank you for your attention, and I hope you found this a little bit interesting at least. Thank you.